Morning, my lady.
Good morning, my
May it
lady.
please the court, my lady. Morning.
Morning, my lady.
Lady Civil, may you please place the matter on record?
Thank you, Judge. Today is Monday, the 30th of October, 2023. Calling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Thank you. Ms. Munjerere, are you ready?
As please the court, my lady, I'm ready.
Yes. You may proceed then.
As please the court. My lady, I confirm that I represent Mrs. Matlodi Daphne Ndlovu, sequential witness number 10 in this inquest court proceedings, my lady. Miss Matlodi Daphne Ndlovu was a social worker at Cullinan Care and Rehabilitation Center during the Life Esidimeni project. My lady, I have drafted and filed heads of argument on behalf of Miss Matlodi Daphne Ndlovu, and I stand by those heads of argument, my lady.
Yes.
And having said that, my lady, I would like to make the following submissions before this court. That although it is correct, my lady, that Mrs. Ndlovu was a member of MDT, of Cullinan Care and Rehabilitation Center, she was not involved, my lady, in selecting patients who were being discharged from Life Esidimeni facilities to CCRC, my lady. She was not involved in the physical assessment as well, my lady, of those patients. Those patients who were discharged from Life Esidimeni facilities, my lady, they were not even handed over to Mrs. Matlodi Daphne Ndlovu. Those patients, my lady, it is on record before this court that they were handed over to Mrs. Dikeleti Manaka, the nursing manager of CCRC. So by that, my lady, I'm submitting before this court that Mrs. Matlodi Daphne Ndlovu did not do anything with those patients who were discharged from Life Esidimeni facilities to CCRC. Even when those patients, my lady, were admitted at CCRC, she was not involved in their day-to-day care, my lady, as she is a social worker. And over and above that, my lady, I would also like to bring it to the attention of this court that even when these patients, my lady, were being discharged to Siabadinga, when they were being discharged to Enka, Miss Ndlovu was not involved in any of those activities. She was not involved in the decision, in taking decisions to for discharging those patients to the two NGOs which were housed in Cullinan. And over and above that, my lady, I will also want to bring to this court's attention that I don't agree with the submissions made by my learned colleague, Advocate Shabangu. As far as he says that Mrs. Ndlovu is in agreement with Mrs. Nyatlu that every decision that Mrs. Nyatlu took as far as the mental health users who were discharged from CCRC to Enka and from CCRC to Siabadinga, that she was guided by the recommendations which were made by the MDT. So it is my submission, my lady, before this court that this honorable court must not make any adverse finding against Mrs. Matlodi Daphne Ndlovu in terms of 16(2)(d) of the Inquest Act, as she did not play any role as far as these patients who were discharged from Life Esidimeni to CCRC and also from CCRC to the two NGOs which were housed in Cullinan. She was just a social worker who did not attend to patients. She was not treating patients. She was only concentrating in her social work duties throughout the Life Esidimeni project.
Any other thing?
And that will be my submission, my lady.
Thank you. Mr. Profi, are you ready?
I'm ready, my lady.
Okay.
Really, from the onset, I wish I could be as brief and say that I merely just stand by my heads of argument, but unfortunately, going to disturb the trend and keep the court a little bit busy for my hour, but I certainly will not go over my hour.
You're going to go over your hour. Is that what you're saying?
No.
All right. I don't expect you to. All right. Proceed then.
The starting point where I want to begin is to just dispel the narrative that has been persistent in Section 27 legal representatives' argument in respect of the three NGOs which I represent, being Ubushlebe Nkosi, Takalani, and Museho Home. So in respect of those three and their respective representatives, but I'm going to be bold enough to say that even if the court considers the evidence of the unrepresented NGOs, there's the submission made is that the mass transfer resulted in the users being transferred to who neglected, tortured, and starved the users. Now, my lady, in light of the public interest in this matter, I think it's important that we guard against a narrative that a blanket statement that is so severe as the users were starved, neglected, and abused, that my submission that is in respect of the three which I represent, there's no evidence before this court that substantiates those three averments made by Section 27. And so because they're so general, I ask that they have no regard or place in these proceedings. Now, my submissions I stand by are my heads of argument. My submissions are merely an amplification in respect of the three NGOs in light of Section 27, and as well as just to be of assistance to the court in respect of correct dates and page references from the heads of argument from both the evidence leader as well as the heads that I had submitted. So I'm going to begin with Patricia Mbasha from Ubushlebe Nkosi because no adverse findings have been made against her. Her evidence is uncontested. What we have before the court is an NGO who was not supported by the department, was not paid for the first few months, was not part of the mentorship program. The MEC had apologized for the finance, the NGO not being financed in time in terms of the agreement. She was not linked to a clinic, so she had to use the equipment and medication from a private clinic. But ultimately, in respect of the two users that passed away at Ubushlebe Nkosi, it's Timothy Ngamalo and William Mvolani. In respect of those two, the crux of the argument is what influenced their demise directly is the issue of the multiple moves, which was sanctioned by the department, and the license. She was not licensed to receive frail elderly users. Now, the evidence leaders succinctly in their heads of argument addressed the aspect that she had continuously communicated with Rochelle Godin in respect of the elder users that she had, the impact it had. Her evidence was the impact it had on the ratio of staff, on her subsidy, and also just their care, that they needed to be moved to a facility that housed frail elderly users. And Ms. Rochelle Godin's evidence was there was nothing they could do. There was no space for them. So what the submissions I make to the court is that it is not Patricia's fault that in respect of these two, Rochelle managed to move other frail elderly users who then survived, and these two who remain then passed away. So Patricia can then not be blamed for the poor planning on the part of the department, nor can she be blamed for there being no space in any other facility in the NGO. Now, my submissions, and this will be throughout, is based on two premises. The evidence leader takes the stance that when a death is natural, it stops there. There's no need for the court to go any further when the causes of deaths are natural. Now, the reason why my heads have been amplified is because if the court is with Section 27, that the deaths may be natural, but the surrounding circumstances were not natural. And the point of medical treatment is to delay death and not bring it further. And that is the premise within the prism of causation and foreseeability why their argument is then that the MEC and Dr. Manamela should then be referred. My argument is then if the court is with Section 27, then in respect of these two surrounding circumstances, it is not, even if we look at the surrounding circumstances, there was nothing Patricia could do, and that what she did do was go over and above in insisting that the elderly and frail users be moved from the NGO despite the lack of support from the department. So if the court were to then assign blame in the surrounding circumstances, that would then be NGO who told the department these two need to move, and they didn't. Whether the court attributes that to Rochelle Godon to say that, is it sufficient for her to have then said, there's nothing we can do, there's no space, or then the argument that then trickles persistently is she was junior, and then the trail leads to the MEC and Dr. Manamela. But that is for the court to then decide on Section 27's submissions. In conclusion, with Esidimeni Inquest, my submissions is merely that if one has regard to the tornado of events that the department thrusted her into, she is certainly not the villain in the story, but in fact the hero in not only saving lives, but also in the way that she managed the users who did remain until they were removed from her care. So it's to dispel the narrative that in respect of the three NGOs, there are no villains here. Now I'm going to turn to Mosego Home, Ms. Mokhosha's evidence. Now, the reason why this portion is extensive is to correct the evidence leader's submissions that in respect of Dr. Makachwa, that the majority of his evidence was speculative and general because it never addressed a particular user. And that's where the evidence leaders leave it. So I disagree with the evidence leader because I took Mr. Makachwa through individual users in respect of their records to substantiate the argument that the records were inadequate and insufficient. Now, and I've canvassed her evidence in paragraph 18.1 of my heads of argument. Now, what I'm going to ask the court, if it's at all possible, what I'm going to do is if we turn to my heads of argument.
That paragraph again?
Her evidence is 18.1 to 18.12. We're going to go to it, my lady.
All right, that's fine. I'm there. Yes.
What I'm going to ask the court to do is I'm going to go through them, but I'm not going to repeat what is there. I'm merely going to add and provide page references to substantiate what is there.
Okay.
So I'm going to follow the flow of the users that is in there from 18.1 to 18.12. So if we have regard to 18.1, Johannes, we're on docket 82. He arrives 5 May 2016 and dies on the 12th of May 2016. Now, for the court's reference, the arrival date, that page reference is 14276 when he arrives. And then the death certificate reflects at 14312. And then there's, that is not in my heads of argument. It's why I'm
okay, let me just note that I can see that those are not there. I'm at paragraph 18. Okay, can you just repeat the 2 pages?
So arrival date is 5 May 2016.
This is now Tlongwani.
Correct, my lady, docket 82.
He arrives when?
5 May 2016.
Yes.
The affidavit.
And the page number?
14276.
14276.
Correct, my lady. He then dies on the 12th of May 2016.
Yes.
The death certificate is found at 14312.
Yes, continue.
Then from my heads of argument, there's no prescription. The periodic report is 2019. The evidence leader confirms that he dies after he was in and out of Yusuf Dadu Hospital, and he died before the ambulance could arrive. The evidence in that regard is found in the heads of argument by the evidence leader at page 54676.
54676.
Correct, my lady. If we then turn to Sam, the next user, docket 103.
Yes.
18.2. His arrival date is 5 May 2016.
Which date?
5 May 2016. Yes. The report confirming that is found at 7243.
7243, yes.
And then he dies on the 5th of March 2017.
Yes.
The death certificate is found at 7249. And the cause of death is under investigation. He was then taken to Laratong Hospital where he died. That reference is 54677.
Just a second. That is, he was referred to the hospital?
Correct, where he died.
Where he died.
Yes, my lady, and that reference is 54677 of the evidence leaders' heads of argument, in which they conclude that his death was natural from the evidence available before this court.
Yes.
We can then move to 18.3. John, docket 109. He arrives on the 6th of May, 2016. That reference...
Just a second. The docket number is 109.
Correct, my lady.
Yes, and he arrives which date?
6 May, 2006. Page reference 15472.
Yes.
He dies on the 10th of November, 2016. The report confirming that is found at 15483.
Yes.
The periodic report dated 2016 is at 15479.
15479.
Correct, my lady. And the background in respect of the user is in my heads of argument.
Okay.
Now we move on to Peter. He is docket 113.
This is now Peter Mvundla.
Correct, my lady.
8.5.
18.5.
18.5.
Docket 113.
Yes.
He arrives on the 6th of May, 2016. The affidavit confirming same is found at 15689.
15689.
Correct, my lady. He dies on the 22nd of June, 2016. That page reference is 15713.
Yes.
The periodic report dated 2012 is found at 15704.
101.
15704.
Okay.
Then the relevant background from my heads remain, and we move on to 18.6 Ishmael, docket 122.
Yes.
He arrives on the 5th of May, 2016. The affidavit confirming that is found at 0.
16320, yes.
He dies on the 3rd of August 2016. The death certificate confirming natural causes is found at 16384.
Yes.
The periodic report dated 2014 is found at 16347.
16347.
And then here I just pause to highlight that in respect of this user, Life Esidimeni was able to provide a summary report, also dated 6 August 2014. And that summary is found at 16359. My submission is then in respect
16359.
Correct, my lady.
Mm.
My submission is then there's no reason why Life Esidimeni was then unable to provide the summary as we see in this user to the NGOs in respect of the other users in assisting in continuous care.
Proceed.
Right, we then move to 18.7, Mr. Hartman, docket 94.
Mm.
He arrives 6 May 2016. The affidavit confirming that is at 6433.
Yes.
He dies on the 29th of August 2016. The relevant page reference is 6446.
Mm.
Now, I'm just going to pause here, my lady, because the evidence leaders in their heads of argument, which I agree with, is the issue surrounding his death was his the loss of weight and him being the way the emaciation happened. Now, the evidence leader, which I agree with, is that there's not a big difference between his weight when he arrives at Mosego home and when he passes away. The only it's not really an issue, but the evidence leaders refer to an arrival weight of 49.7, and they refer to an affidavit on page 6452. But when I peruse that affidavit, there's no reference to weight there too. So
The affidavit is where on page?
6452.
Yes.
So the affidavit they refer to makes no reference to his weight. But the point I'm wanting to make, so when I go through the docket, the earliest reference to his admission weight at Mosego in the admission report is 50 kilograms, and that's on page 6385. So perhaps I'm mistaken, and the evidence leaders do have a
Page
385.
385.
6385.
Yes. What is the issue here?
It's not really an issue, my lady. It's merely
Yes.
that I don't know where they got 49.7 from being his admission weight. But my submission is this, that it's so, whether they confirm it or not, whether we deal with 49.7 or 50, their submission remains correct, that the weight loss is not significant to say that he lost all that weight at Mosego home. So whether or not they provide us with where they got 49.7, the submission remains correct. I'm merely bringing to the court's attention that when the court has reference to their heads of arguments and goes to that page, it won't find that weight number there. But even if we work on 50, their submissions remain correct, is merely the point I'm making.
Yes.
The evidence leaders conclude that there's not sufficient evidence to show that the deceased died of anything of unnatural causes. Then my submission is then, given the short period from which the users were admitted in light of inadequate medical records, it hampered the NGO's ability to ensure continuous care.
This is included in your hits, no?
Yes, ma'am.
Paragraph. This is now in respect of all of them.
All of these that I just went through. Correct.
No, I'm referring to, you are now referring to all the users.
I'm specifically referring to the users.
To this one.
To this one.
Okay. What about you? You are saying?
To docket 94, but it will be, I'll elaborate in detail because it's going to be the conclusion I'm going to make in respect of additional specific ones.
Okay.
So
in respect, just make that submission so that the court can follow your argument.
So in respect of Mr. Hartman, given his short period at Mosego Home, that the inadequate medical records hampered continuous care, and that lies with Life Esidimeni and not Mosego Home, which there is then prima facie a case for referral in terms of 16.2D. Is this I'm making? Now, if we can then turn to 18.8, Hermanas, his docket 87.
This is now Mr. Bronkhorst.
Correct, my lady, 18.8.
Yes, what about him?
He arrives 10 May 2016.
The docket number is?
87.
Yes.
His arrival of 10 May 2016, that reference is 147484767.
Yes, continue.
We move to the next user, my lady, 18.9. Docket 129.
Yes.
He arrives on the 10th of May 2016. That reference is 16828.
Yes.
He dies on the 28th of February 2017.
Which date?
28 February 2017.
Yes.
That reference is 16908. And his periodic report is dated 2011. I'm then going to turn to the next user, 18.10, David Mabati. Here I'm going to make a very short submission, being that in respect of David Mbati.
This is now docket number
86. And I'm going to include Daniel Malan, being docket 102. And the reason for that is because I agree, I'm not going to waste the court's time, that I agree with the evidence leaders in respect of docket 86 and docket 102, that no living can be held responsible for the cause of these deaths. So there's no need for further investigation or submissions in that regard.
Okay.
And then 18.11. is docket 81. He arrives on the 10th of May 2016. Reference is 14217. 14217. He dies on
14217.
Correct, my lady?
Continue.
Dies 23 October 2016. 14222. No periodic report, so his treatment was based on the medication he received and was figured out between the NGO, the clinics, and the doctor's visits. Then we move on to the last one, being 18.12, Rebecca, docket 116. She arrives on the 2nd of June, 2016. That
Which date in June?
2nd June, my lady.
Yes.
Reference, page reference 15946. Death 27 June 2016. The death certificate reflects at page 15987.
Yes.
It indicates natural causes. So she died at Museko home the same day she was just discharged from hospital. She had a heart condition, but she was not admitted to Museko home with medication for her heart. So that is clear that there was a fatal interruption of care, which are clear with reference to the Mental Health Care Act. The relevant sections there, my submissions are merely that Life Esidimeni destabilized the users that I referred my lady to now. They destabilized their mental capacity, which needed to be remedied by the NGOs, and that it was unreasonable to expect the NGOs to puzzle together the correct and appropriate care. It's clear that the medical records interrupted the care of the users, and as a consequence of Life Esidimeni's breach of Section 30 of the Mental Health Care Act, my submission is then that breach then prompts Section 70, which relates to offences, and that is an offence that to neglect a mental health care user in respect of failing to provide adequate medical records. And any organization or facility who does so is guilty of an offence. My submission is then that the breach is clear, and the consequence of that justifies referral of Dr. Makachwe for prosecution in terms of Section 16(2)(d). Now,
what does that this submission, what is it informed by? What is it? Are you saying that he refused the transfer of medical records?
what I'm saying is
just yeah.
His version.
Let me understand your argument. Yes.
His version is that he had instructed all the staff to ensure that the required documents are given to the NGOs.
Yes, correct.
When I took him through it, we had agreed that even if we just have regard to the records which must, in light of the act, be given to NGOs, that those records were not given. And his version was then the department's officials are to blame because they would have lost those records in transit. So my submission then is one has regard to the documents that would have, if we believe his version, that were lost, that it cannot be that such specific documents were then lost in transit by the department officials when we look at how far back the periodic reports go and some not even being there. And if we look at the evidence before this court, there's not a single NGO before this court that says, I received sufficient medical records from Life Esidimeni or the department officials, which then means that in transit of all the users to the NGO, if we believe his version, is that they then lost those records.
Do we have evidence that that negates that evidence of him to say that the Life Esidimeni has provided the records as to what happened in between? Nobody knows. Do we have? Yes. I just want to understand what you're saying. At least I'm happy that Mr. Van Bergen will deal with this at a later stage.
So my submission is no, because when we look at my cross-examination, I then asked him that Dr. Sukukune went to Life Esidimeni, explaining that they need these medical records in order to assist with continuous care. He then said she needed to follow the protocol, which was to go through Dr. Manamela, which she then did. Dr. Manamela then wrote to him saying the NGOs need these documentation. He then said, ink and paper. If you bring the ink and paper, we can then provide those records. So my submission is then that the referral is based on the fact that Dr. Mkwatshwa unreasonably put ink and paper before the continuous care of the mental health care users. That had he provided that information as requested by Dr. Sukukune on behalf of Masego and Takalani and by Dr. Manamela, continuous care would not have been disrupted because the records would have been provided.
Okay. Thank you. Anything else?
Here it kicks in again that should the court agree with the evidence leader that natural causes equals end of inquest, that is for the court to decide. My submission is then if the court is with section 27 and finds that through the prism of foreseeability and causation, that the surrounding circumstances are unnatural, the deaths were then brought forward. And I'm not going to repeat that the legal argument they've presented, but that argument then in their view facilitated, and there the act is clear. Now, Mary, I want to move to the bridge between Takalani and Masego home. Here, I'm not going to belabor the point in respect of the success of their appeal. What is before the court is that they appealed the Ombuds report. They were successful in respect of infrastructure, staff, and a lot of contentions that were before this court. And I go through it in extensive detail in my heads of argument, so I'm not going to do it again. The only submissions I want to make to the court is that there is no evidence before this court that could persuade it from the findings made by the tribunal. So what the crux of my submission is the tribunal had raised clouds of doubt. It made the findings, but said that it doesn't have before it, pathology reports, the path of ending of the users, it's not aware of. Now, my submission is that if this court had that in detail, so the clouds of doubt that is expressed in the tribunal's judgment have been fully canvassed before this court. And so my submissions are that the findings remain, because none of the findings that were made by the tribunal were disputed before this court. So if we have regard to the evidence, nothing supports.
But we know for a fact that when the tribunal heard the matter, it didn't have the opportunity to hear what we are hearing in this inquest, isn't it?
Correct, which is why I'm saying that the doubt it expressed to say in terms of like pathology reports and the like, it doesn't have the benefit of. My submission is this court has the benefit, and so.
But you are saying that doesn't change the conclusion of the tribunal. Is that what you're saying?
That is what I'm saying. My submission is that even when we supplement that doubt with the evidence before this court, there's no evidence that changes the findings made. Dr. Sukukuna's evidence remains and is uncontested. So the evidence that was presented in respect of licenses, in respect of everything before the tribunal, if one supplements that with the evidence before my lady in respect of the medical evidence, there is nothing before this court that changes the conclusions reached by the tribunal. So I merely just want to then emphasize paragraph 27.10 of my heads of argument, which relates to this aspect, plus the Masego Life Esidimeni documents issue. 27.10 at page 55324 confirms, I had confirmed with Professor Leslie Robertson that even in respect, if we if we view Dr. Makatra's evidence that the department is to blame, he gave all the documents, the department lost it. Even when the expert panel report was conducting their investigations, she confirmed that even at the tail end of the investigation, the clinical records made available from Life Esidimeni were often incomplete. So there's nobody before this court that ever received complete medical records from Life Esidimeni. So the argument to then be that it's lost should be rejected by this court. And then the submissions I just made to the court now are more succinctly contained and are important to this court is 27.16.
Yes, continue.
And this is the point that I'm making, and it more succinctly sets it out here. The clouds of doubt before the tribunal being 27.16. Due to the absence of further data from Life Esidimeni, we have Life Esidimeni before this inquest, so their version is fully before this court. The lack of detailed forensic exploration of the causes of death, we had the pathologist telling the court in respect of where they could, and the reports we did have, those aspects were canvassed. The absence of post-mortem confirmation on the final pathway, we have all of that. Health for laboratory investigation, we have it. So that's where I submit that the clouds of doubt was fully canvassed with the information available before the inquest. So in respect of Maseko and Takalani home, there was not an iota of evidence presented to dispute any of the findings that the tribunal made.
Okay.
Now, my lady, that should conclude Maseko home, Ebuhlebeng Nkosi, and the tribunal submissions relates to both Takalani and Maseko. Now I'm going to conclude in Deborah docket 96 in respect of the submissions made on behalf of section 27. Now, I'm going to keep it brief on this basis that
this is now Deborah
Patler, docket 96.
Discussing, I see here. Oh, it's not mentioned in your head.
It's not. It's mere.
So this is now Deborah Petla.
Docket 96. It's a mere answer to the submissions made in section 27's heads of argument. Now, where I find myself is one, to be of assistance to court, but also that what section 27 does is they attribute the blame to the MEC and Dr. Manamela and not any member of Takalani. So my submissions are then limited to the vehemence made by section 27 in respect of Takalani, because what I don't want to happen, in fairness to everybody in the inquest, is if the court were to agree with section 27, it must base it on what is factually correct. So where I come in is that if the court were to agree with section 27, that in respect of their submissions made of the state of Takalani, and that state is why they then refer Dr. Manamela and the MEC, because had they not referred the users to Takalani, they wouldn't have died. So my submissions are to the state of Takalani, that the submissions they're making are factually incorrect. So when if the court were to make a finding in respect of Deborah being moved, and that blame is attributed to Dr. Manamela and the MEC, I'm going to leave it to their legal representatives to canvass the detail in respect of the two, but I'm merely going to focus on the vehemence made in respect of Takalani. So,
yes, if you can just explain on what basis do you say they are incorrect?
I want to start at the beginning. That
yes.
What brings Deborah in is they begin with the transfer. So the transfer is based on, there was that litigation in which Takalani was the fourth respondent, and that application was dismissed. She then, subsequent to the litigation, she arrives on the 23rd of March, and she dies.
23rd of March, 2016.
And she dies on the 26th of March, 2016. So she's only there for 2 nights.
This is now in Takalani.
Correct, my lady.
Yes.
So the report in respect of that,
Just a second.
The report confirming that and the necessary evidence is at 6576.
Yes.
So the argument presented by Section 27 is in respect of the license, that they were licensed to house disabled children and not adults. So at the time of the transfer, she arrived at Takalani and they didn't have the license to house the users they had. Now, if we have regard to the license, which is at 20,333, where I part ways with Section 27, and perhaps in reply they'll correct if I understand the submission correctly, is what they're doing is they're saying that the license was backdated to the time the users came, when factually, when the users actually arrived, Takalani didn't have the necessary license, and only after the fact did they get the license. Now, why I part ways is because that what they're doing is taking evidence in respect of the new NGOs, that was the evidence, the backdating of licenses related to new NGOs. There was no evidence. Dr. Sukuna was never asked, Dr. Mena was never asked in respect of the backdating of Takalani. And why is that? Because there was a relationship between the department and Takalani, and even the tribunal comments when it says that there is a proper license. There was a proper license because there was a relationship between the department and Takalani, and they're not like the other NGOs. So the vehement that it was backdated and that they didn't have the correct license is then false. So I submit that then finds relevance here, that it's incorrect to say the license was backdated, because in respect of Takalani, we don't have that evidence. We have the evidence that they were renewed year upon year upon year. So now, if regard is had to paragraphs 399 to 403 of section...
Yeah, just a second. Yes, let me get those dates.
It's the paragraph references which I'm disputing, my lady. It is of their heads of argument, paragraphs 399 to 403.
And the pages? But I'll get the pages.
Okay, ma'am.
Or do you have the pages? You can just give them to me if you have them. If you don't, it's fine. I'll get them. Let's proceed.
Okay, ma'am. The submissions I'm making, my lady, is that, as was the case with the submissions they made in the judgment which dismissed the application, these contentions they make are then again based on inferences. They want the court to make inferences that must be drawn from the same papers that are placed before this court. So my submission is the same thing is happening again. So I'm going to borrow from the words of your brother, Justice Valley, where he had stated in the judgment, and the page reference there too is 18924 of his judgment.
18924.
Correct, my lady. He says that the problem with the contentions is that it asks the court for a finding of fact based on inferential reasoning, which findings will be in direct contrast to the unequivocal factual vehemence made before this court. Now, his submissions are borrowing identical from the words of Justice Valley, that the same thing is happening here again, that in respect of Deborah, we have affidavits by Dr. Sukukuna. We heard her evidence in respect of the care of Deborah, and it wasn't contested. So to now grab at certain vehemence, the facts remain the facts. Dr. Sukukuna's version was not tested. She was not cross-examined on these aspects in respect of the care Deborah received. Her cross-examination by Advocate Hassim was limited to the aspect of the CCTV cameras, in which Dr. Sukuna explained that she had raised funds to install the CCTV cameras, that they were monitored. It was a managing tool. Deborah was placed in front of a a nurse. The ratio was 1 to 2, and that she was satisfied with the care and the observation of Deborah. And that's where it ended. There was nothing to rebut. She'd even told the court that the manager had gone through the tapes, the investigating officer was provided with the tapes, and she was never told by anybody that there was anything untoward from the supervision of Deborah. So those are the facts before the court. So these inferences which Section 27 wishes the court to draw, I submit the court should equally draw and that it's unwarranted conclusions in the light of Dr. Sikukuna's evidence. Then what we also have before the court is they create this atmosphere that Takalani was this nasty, dirty NGO, yet the evidence before the court is that after the litigation, representatives from Section 27 went to Takalani and they were happy with it. So those representatives should then have explained what the issues were that they had with Takalani. You can't in one breath say our representatives went, they were happy, but then the argument at the end of the day is that it was this horrible place when their own representatives were satisfied. Then thirdly, the findings by the tribunal remain.
Just a second. Yes, continue.
So then the relevant to Deborah as well is that the contention, if there was any issue or they didn't agree with the findings made by the tribunal, those aspects should have been put to Dr. Sikukuna, that the tribunal may have made this finding, but in light of the evidence of A, B, C, D, it changes that, and we put it to you that the staff was incompetent or the place wasn't proper, but that wasn't done, my lady. So there's no evidence to dispute any of Dr. Sikukuna or the tribunal's findings. But my submission is that even if they make a noise around the smell, that is factually not the cause of Deborah's death. If we look here, I agree with the evidence, not the evidence, the submissions made by the evidence leaders that Dr. Talatala's evidence was she should have been monitored more closely. We don't know what more closely means after the evidence given by Dr. Sikukuna on how she was monitored. So we don't know what that is, what more means, what more leader. And this is where I disagree with Section 27, with the evidence before the court, is that the presence of the stomach content, it is unknown how and with what caused the injury. So when I had cross-examined the pathologist, I had put to him that if he attributes negligence to Takalani, even though he says that the contents in her stomach did not injure the larynx, which doesn't relate to the cause of death, he wasn't even aware that she was only there for 2 nights. She wasn't there for a very long time, nor was he aware that she was only at Takalani on a leave of absence. Now, the court will remember that when we dealt with the pathologist's evidence, because he had said it's unknown, the majority of his evidence then became speculative. Everybody was giving their version of what could have possibly happened to Deborah, and eventually it concluded that we need to stop that line of questioning because everybody's just going into the realm of speculation. So the nature of the cause of death is unknown, which then rightfully places her in the group where the court is unable to make a finding in respect of Section 16(2)(b, because the evidence leaders correctly emphasize in their heads that Dr. Marilla's testimony is not that the eating of the objects in her stomach killed her. It is unknown how the larynx was injured. So the transcript to that, in where he states that what is found in her stomach is not the cause of her death, that is found, and that merely the plastic found confirms her propensity to eat rubbish, but not that caused her death. So those transcript references are 54481 from line 17.
54481.
Correct, my lady? And then confirmed again at 54483 line 10.
54483.
From line 10, my lady. So based on that testimony, it is incorrect for section 27 to then state in paragraphs 405.
Just a second.
That the swallowing of
paragraph
405
of their heads.
Correct, my lady. That swallowing of the plastic was in fact at Takalani, and that it places the action which caused her death at Takalani.
Yes.
Those submissions are factually incorrect. My last point, my lady, is big emphasis was made in respect in their heads of argument about the labor issue which had happened at Takalani. My submissions are twofold. One, the labor issue happened after Deborah's death. So the labor issues can then not be the reason for Deborah's death. But also, when I cross-examined Professor Robertson, I'd taken up the labor issue with her, and her evidence is that she heard a rumor about the labor dispute at Takalani. She then took that rumor up with Dr. Manamela. Dr. Manamela addressed it with Dr. Sukukuna, who wrote her a report, and the issue was settled. So what the heads of argument leave out is that it was based on rumor, not fact, and later was confirmed to be false, that it wasn't impacting the user's care. But that relates to everybody else. My submission is that we can't use the labor issue to impact Deborah because it was after the fact. Well, the last minor thing I wish to just draw to the court's attention is in respect of the stats by the professor. My submission is merely that the submission was made, that the court must have more regard to her stats than the stats provided by Life Esidimeni in respect of the winter stats. My submission is that is incorrect because the professor's stats are based on the demise of the population as a whole, whereas Life Esidimeni is specific to the users we're dealing with, and also specific to the demise of mental health care users, and that finds far more relevance and bears more weight than the population as a whole. But that doesn't take, it's merely just a circumstantial side note. My submissions then remain, my lady, and if there's anything additional the court wishes me to address, those are my submissions in respect of Esidimeni Inquest, Mostekga Home, and Takalani Home.
I think you have addressed the issues extensively. Thank you so much.
As the court pleases.
Thank you. Let's see, it's 7 minutes past 7. I don't know if Mr. Van Bergen would like to start now, or can we take the tea adjournment now?
Mr. Van Bergen. My lady. My lady, I suggest that we perhaps take the tea adjournment now, and then I can address the court uninterrupted.
Okay. Thank you so much. We can take the tea adjournment. We will resume at 11:30. Thank you.
As your ladyship pleases.
May it please the court, my lady.
By Mr. Profi. Mr. Profi.
Maria, I apologize to the court and Mr. van Bergen for interrupting. It was just brought to my attention there was a conclusion which I didn't make clear in respect of Masego Home, the arrival dates and the death dates. That the conclusion I didn't make is that the referral of Dr. Mokwacho is only relevant to the following dockets. That it's not all of them. It's only in respect of docket 82.
Just a second. Yes.
109, 82,
82 to 109. Or
No,
82, 109.
109, 113, 122,
Yes.
94,
Yes.
87, 81, and 116.
Okay, is that all?
That's all, my lady.
Thank you
Apologies for the interruption.
Mr. van Bergen, over to you.
Thank you, my lady. My lady, I cannot promise to be as brief as any of my preceding colleagues. It may also be that I may need a bit more time than the hour that was allocated, but I will endeavour to stay within the allocated time slot. My lady, I intend addressing the court firstly in very brief terms.
Just bear with me. I just want to
as your
have
ladyship
your
pleases.
heads next to me.
It's from page 55622, my lady.
I filed them the way I wanted them to be. So I'll just locate them very soon. Yes, you may proceed. I have them now.
Thank you, my lady. The first aspect is I briefly wish to address the issue of the onus that has to be discharged.
Yes.
As it appears that there is some difference of opinion there. Then secondly, I will address your ladyship also issue of foreseeability. And then thirdly, I will address the submissions made to your ladyship by Mr. Profi in his client's heads of argument. If I may start with the issue of onus, my lady, I submit that, well, maybe it was just me, but that the waters have been muddied somewhat by what has been said by some of the preceding colleagues. I would submit that the description of what is required in the decision of Inre Gunewe and others.
Is that included in your heads?
It is in my heads, my lady. Your ladyship will find it from page 55626, and the case reference is at the footnote at the bottom of page 55627. And if I may refer your ladyship to the second paragraph on page 55627, and I submit that that very clearly sets out what the threshold is.
Oh, Goniwe. Yes.
Goniwe.
Correct. Yes, I saw that.
Where the court said, bearing in mind the object of an inquest, it is my opinion that the test to be applied is not the, quote, beyond reasonable doubt, unquote, test, but something less stringent. In my opinion, the test envisaged by the Inquest Act is whether the judicial officer holding the inquest is of the opinion that there is evidence available which may at a subsequent criminal trial be held to be credible and acceptable. My lady, I submit that that really describes what your lady has to look at. Is there evidence before your ladyship which may at a subsequent criminal trial be held to be credible and acceptable? And if so, and if it supports a conclusion in terms of section 16.2d of the Inquest Act, then your ladyship would be in a position to make a finding in terms of that subsection. And that is supported, my lady, by the reference to party and another. The quotation, it is in Afrikaans, my lady, in paragraph 3.2.3. I don't want to read it into the record, but I submit that that makes it clear what evidence will attract or may attract a finding in terms of section 16.2d. Credible and acceptable evidence. My lady, I also in paragraph 3.3 on page 55628 referred to the position in the United Kingdom in inquests pertaining to suicides and unlawful killing, which this matter pertains to. And there the court has ruled that the test is that which applies in civil litigation, i.e. On a balance of probabilities. And I mentioned that in the heads as it is something that your ladyship may wish to consider and, if deemed appropriate, incorporate in your ladyship's finding. It is a more easily understandable test than that in Goniwe and the other decisions referred to, and one with which legal practitioners specifically will be more at ease and conversant with.
Yes.
Finally, against that background, I turn to the issue of foreseeability, and foreseeability is important in respect of the only two criminal offences which may be relevant to this matter, and that is either murder or culpable homicide. Both involve foreseeability as part of the test, and as far as murder is concerned, specifically the test for dolus eventualis.
Yes.
My lady, that test requires, as has already been said by a number of my colleagues, subjective foresight of the possibility that a particular act or omission could have fatal consequences, and secondly, a disregard of that consequence or reconciling one with the foreseen possibility. My lady, I mentioned in my heads of argument at the end thereof that if one looks at what Dr. Robertson said, she said even when they were warning the department of the possible consequences prior to the transfers being effected, that there may be risk and that there was risk involved, she said death never was contemplated. Dr. Talatala equally said in his evidence that in all the warnings, all the letters, they never specifically mentioned death as a possibility. So the question is, can one, and can the court specifically with respect, make a finding that death had been foreseen subjectively and disregarded by any of the role players in this matter? And I would submit, my lady, that the following decision may be of assistance to the court. It is the matter of Van Skalkwyk versus the state. It's not in my heads, my lady.
Van Skalkwyk.
Versus the state.
Yes.
And it may be found on the website of the Supreme Court of Appeal, and the reference is bracket 680 stroke 15
680
stroke 15 close bracket.
Yes.
And then square bracket between square brackets 2016.
Yes.
ZASCA 49. And it's a decision on the 31st of March 2016. The court consisting of Justices Lewis, Cheeky, and Willis, Judges of Appeal, and at that stage Plaskett and Bartman, Acting Judges of Appeal. And I wish to refer specifically to paragraph 15, my lady.
Yes.
Where the following was said: in this case, the state had to prove beyond a reasonable doubt that A, the appellant had had the subjective foresight of the possibility that striking the deceased on the upper part of his body with the hay hook could have fatal consequences, and B, the appellant had a disregard of that consequence. Put differently, he had reconciled himself with the foreseen possibility. Then the court says the two legs are not considered in isolation. Brandt J.A. in State versus Humphreys described the test as follows. Quote, on the other hand, like any other fact, subjective foresight can be proved by inference. And that's the important aspect here, my lady, that subjective foresight can be inferred. Moreover, common sense dictates that the process of inferential reasoning may start out from the premise that, in accordance with common human experience, the possibility of consequences that ensued would have been obvious to any person of normal intelligence. The next logical step would then be to ask whether, in the light of all the facts and circumstances of this case, there is any reason to think that the appellant would not have shared this foresight, derived from common human experience, with other members of the general population. Well, lady, and the importance here is that there is evidence of warnings, specifically by Dr. Nkachwa, prior to the commencement of the transfers.
Yes.
And he referred to a previous similar episode in 2007 when a number of children were transferred from Life Esidimeni facilities to an NGO, following which transfer 2 of the children died, and the remaining, I think there were 13, were then returned to Life Esidimeni facilities in a severely malnourished and dehydrated state. And against that background, he referred specifically to warnings that he gave the mental health department and Dr. Manamela. And I would submit, my lady, that that is something that your ladyship would probably be minded with respect to take into consideration when assessing the submissions made by Section 27.
Continue.
Thank you, my lady. I then turn to the submissions made by Mr. Prophy in respect of Life Esidimeni, which centers really on an allegation that Life Esidimeni had not provided sufficiently detailed or complete documentation to specifically the NGOs represented by Mr. Prophy, although he cast wider than that, and that those NGOs had accordingly been prevented from appropriately treating the users who had been placed in their care. At the outset, my lady, I wish to submit that Mr. Profy's submissions are based on speculation to a large extent and leaps of logic that do not bear consideration. And I will demonstrate that in my further address to your ladyship. In particular, my lady, his submission that Dr. Nkachwa should be, or that a finding in terms of section 16(2)(d) of the Inquest Act should be made in respect of Dr. Nkachwa is devoid of logic and lacks a factual foundation. Lady, the starting point in addressing Mr. Profy's submissions is, what does the law require an entity such as Life Esidimeni to provide to a receiving facility when a user is transferred? Now, lady, both the Mental Health Care Act and the National Health Act require only that a discharge report be to the receiving facility. In the context of mental health care users, the Mental Health Care Act is more specific. Section 16 refers to the necessity of a discharge report.
This is now section 16 of the Mental
Health Care Act, my lady.
Okay.
And regulation 17 of the regulations promulgated in terms of the Mental Health Care Act specify that Form MHCA 03 be used, and that is the discharge report.
Form
MHCA 03.
Yes, okay.
Well, lady, this was put by me to a number of witnesses, but in the context of the present address, it is only necessary to refer to one, and that is Mrs. Mogosinyana, the clinical manager of Mosego Home, who confirmed that they had received discharge reports in respect of all users. In fact, she made that confirmation in reply to a question by your ladyship. And your ladyship will find this on case lines 46257 from lines 12 to 17. This confirmation is important in two respects, my lady. The first, obviously, is it verifies that there had been compliance with the Mental Health Care Act. And secondly, it illustrates that the information contained in the various dockets upon which Mr. Profy relies is not accurate. For example, my lady, in paragraph 18.5, on page 55315, it is said that he had no discharge form, no prescription. My lady, Mrs. Mogosinyana herself had verified that discharge forms had been received. In fact, she also verified that prescriptions had been received. In respect of all the patients or the users. Your ladyship will recall that her evidence was that those documents been provided on the date that the various users were collected, but were fetched from Life Esidimeni the following day. So insofar as it is alleged by Mr. Profi on behalf of his clients, and I will in due course address whether it is on behalf of his clients and on their instructions. Insofar it is alleged that there were no discharge reports or prescriptions, that is incorrect, because by Mrs. Mogosinyana's own admission, those documents were received. And your ladyship will be aware that during the course of the proceedings, there were a number of difficulties encountered with the dockets. Some contained documents that didn't refer to the docket in respect of the patient or the deceased mentioned in the docket. Others had incomplete documents. For example, where only odd pages 1, 3, and 5, were copied. And that is not indicative of a failure to have provided sufficient documentation. That is indicative of improper compiling of those dockets. And everything was compounded by the fire at the headquarters of the Gauteng Department of Health, where all the original documents were destroyed, as we were told. My lady, what was provided by Life Esidimeni? The evidence was, and this was by Dr. Mkachwa and by Mrs. Buthelezi, and confirmed by Dr. Lenkwani and Ms. Zanello, was the form MHCA 03, the discharge report, a prescription, a physical examination report, a community referral form, and periodical reports. Much of the complaints raised by various parties as to records related not to what they had been provided with, but related to, as they put it, a failure to have provided the patient files. Clearly, there had been an expectation that the entire patient files would be provided and had to be provided. My lady, that is not the case. It was made abundantly clear, not only by Dr. Mkachwa, but also by other witnesses, inter alia Dr. Lebete, Dr. Talatala. Dr. Talatala, for example, and this is on page 45381, from lines 4 to 7, said it would not be helpful to release the whole file from Life Esidimeni to the NGO. That summary that we discussed earlier on of the important things to include, that is all. I mean, that can go a long way. And that was with reference to the discharge report. Your Ladyship will further recall with respect when there was the debate about whether the entire files should have been provided or not, that Dr. Mkachwa's evidence was that an arrangement had been entered into with Dr. Manamela that the records would be made available by Life Esidimeni for the Department of Health to copy and to then do with those copies what they needed to do. That was not disputed in Dr. Mkachwa's evidence. In fact, Dr. Manamela confirmed that arrangement. She testified that Mr. Lehau had endeavored to obtain or to go and make copies, but had been prevented from doing so. Lady, that version had not been put to Dr. Mkachwa or Mrs. Buthelezi. It surfaced during Dr. Manamela's evidence for the first time. And it is certainly not mentioned by Mr. Lehau in his affidavit, which forms part of the record. In fact, Mr. Lehau makes no reference whatsoever to difficulties concerning records from Life Esidimeni. And perhaps, my lady, the proof of the pudding as to what should have been provided can be gleaned from a facility of the Department of Health itself as to what they provided receiving NGOs with. And I'm referring to Cullinan Care and Rehabilitation Centre. When they transferred patients, they provided the referral form, the community referral form, to refer to in the heads of argument on behalf of Mrs. Nyatlo at page 55166 to 7. It's referred to
55166 to 7.
To 7. They refer to a discharge form, a discharge summary, a copy of a prescription, and 1 month's medication. What Life Esidimeni did, my lady, and for which they now seem to be castigated, is they went over and beyond that. They provided the periodical reports because that gave a historical insight into the various users, which Dr. Talatala said was a very good idea. I'm paraphrasing him. And one must bear in mind, my lady, that as regards the objections or arguments that were raised that, well, if it was an outdated report, the patient's condition may have changed in the meantime. The hallmark of the patients, the mental health care users at Life Esidimeni, especially those transferred to institutions such as Mosego and Takalani, the very old ones, the frail ones, the ones with comorbidities, was that they were chronic, stable patients. In other words, they had conditions which were chronic, ongoing problems, and they were stable in those conditions. So the prospects of any change, sudden change, would be unlikely, although of course it could be brought about by an exercise such as the Marathon Project. but that would be unrelated to any historical condition. Lady, the one aspect that is rather puzzling, and I'm putting it euphemistically, is the late stage at which allegations arose of insufficient records. One would have expected, my lady, that this would have been raised at an early stage, in writing, recorded by both the NGOs and the Department of Health. And yet, my lady, when the knowledge of a number of deaths surfaced and questions were asked as to the cause, the answer was not, well, it was to be expected because Life Esidimeni provided insufficient information. It was, no, these are normal deaths. So it was fobbed off, my lady, which is an improbable thing to do where consistent and repeated complaints of insufficient information and records lacking in some or more respects had been raised. And it just makes one wonder, why did it only arise at a later stage then? And why is there nothing in writing? Reliance is placed on an email said to have been sent by Dr. Manamela to Dr. Mkachwa after Mrs. Sekukuni, or Dr. Sekukuni, had sought to obtain records and had been referred to Dr. Manamela by Life Esidimeni. And we are told that in response to that approach by Dr. Sekukuni, Dr. Manamela sent the email dated 3 June 2016, which your ladyship can find at case lines 34797. I would request your ladyship to turn to that page.
Just bear with me here.
As your ladyship pleases.
Yes, I'm there.
My lady, it's unfortunately a poor copy. It doesn't read very easily, but I will read it into the record. It is addressed to Dr. Morgan Mkachwa at Life Esidimeni. It is from Dr. MJ Manamela, Director, Mental Health Directorate. And the heading is Request for Medical Reports of Mental Health Care Users. Now, my lady, in reading the content, I would request your ladyship to bear in the back of your ladyship's mind that why this has been provided is ostensibly because it is a request for medical records, because it is required for clinical purposes, for patient care purposes. Now, it reads as follows. The contract between Department of Health and Life Esidimeni will be ending by the end of June 2016. Due to the time limit of the ending of the contract, the process of moving patients from Life Esidimeni care centres to NGOs, homes and hospital has already started. Some of the mental health care users that have been moved are not getting the disability grants. Have not been getting the disability grants. The disability grants are necessary for mental health care users who will be discharged home and to the NGOs. Discussion with SASSA revealed that they cannot continue with disability grants application without medical records. We therefore request Life Esidimeni to send us the medical reports of all mental health care users who have been moved out of Life Esidimeni care centres to various facilities in order to fast-track the application of disability grants. We will appreciate it if we can receive the requested information by 10 June 2016. Please let us know if you need some assistance in this regard. Now, my lady, this letter was not written by some clerk in the Department of Health. It was written by the director of the Mental Health Directorate, the person who holds a number of degrees, inter alia, a PhD in nursing science, psychiatric nursing science, who completed a doctoral thesis, who expresses herself extremely well, as was demonstrated during her evidence before your ladyship, and who it is inconceivable to have asked in a letter like this pertaining solely to the issue of disability grants. Mistakenly, whereas she had intended to request the records for clinical purposes. It does not hold, my lady. It is beyond improbable. And any effort to try and convince your ladyship that this letter had to do with a request for records because patient care was being compromised cannot be upheld. This is a red herring of the reddest hue I have seen. My lady, furthermore, one would have expected that where patient care, clinical care was being compromised due to a lack of records, that is an issue that would have been discussed at the weekly meetings of the Mental Health Directorate and would have been raised repeatedly. My lady, there is only one entry in those minutes pertaining to records that had been requested specifically for patient care purposes, and that was early in the transfer process. Your ladyship will recall that the very sick, the very frail mental health care users had been transferred to state mental institutions, amongst others Weskoppies Hospital in Pretoria. And Weskoppies Hospital specifically asked that complete patient files be provided to them, which was done, and that was recorded. But there is no other recordal that I could find, my lady, and if anyone has proof to the contrary, I will gladly stand corrected, which once again, my lady, places suspicion over the whole issue of alleged unsatisfactory records having been raised at a very late stage.
If I may, Mr. van Bergen, on this issue, I don't want us to delay on the issue. The evidence is on record. But I'm just asking myself this issue that complete medical records were requested by Vescopies from Life Esidimeni and they were provided.
That, if I may preempt your ladyship's question, they were asked via Dr. Manamela.
Oh, okay. Oh, this is a statement that we're making regarding Dr. Manamela, not
Yes,
from Life Esidimeni, because what we know is that from Dr. Mkachwa's evidence, as you have mentioned, there was an issue that if the department would want to get the complete medical records of the patients, the fact that some of them have been at Life Esidimeni for quite some time, they had to make provision for a photocopier so that copies should be made by them, the department themselves. Yes. So that's why I was raising this. Yes. So this is something that was said by Dr. Manamela.
Yeah, no, this was the request came via Dr. Manamela.
No. I'm referring to this the statement that we have just made regarding the fact that the court could not lose sight of the fact that some of the frail users were transferred to hospitals like Vescopies, and Vescopies requested complete medical records, which were provided.
Yes, that was.
So I was asking myself in relation whether that is something that came from Life Esidimeni, that Life Esidimeni provided the records, and I wanted to check if indeed, because that was never in the evidence to say that they were also requested to make copies. Now you have clarified it to say this came from Dr. Manamela's evidence. Is that correct?
Well, it comes from the minutes of the Mental Health Directorate, my lady.
Oh, okay. All right.
It's recorded in the minutes.
Okay.
I cannot recall if Dr. Manamela specifically dealt with this aspect.
Yeah, it's fine, but it's not a big issue. Continue.
Which just emphasizes, my lady, that if the approach had been made on the correct manner, there is no reason why Life Esidimeni would not, by means of the agreement with the Department of Health, that the department make the copies, there is no reason why it would not have been done. That arrangement existed. So if there had been requests to Dr. Manamela by, for example, Mosego Home for certain copies, there is no reason why Dr. Manamela could not have sent somebody to have those copies made, because there is no dispute that such an arrangement was in place, that the records would be made available.
Okay.
My lady, now, in the whole context of the allegations contained in Mr. Profy's heads of argument, the evidence of Mrs. Mavis Magosinyana is important. As I said, she was the clinical manager at Mosego Home. She testified that her duties as senior nurse entailed taking care of patients, providing medication, keeping up the patient files, and importantly, my lady, she testified she was present when patients were received. She accompanied patients. My lady, when I refer to patients, it's actually mental health care users, but I'll use the terms interchangeably. She accompanied the mental health care users when they were fetched from Life Esidimeni, and she took part in the inspection and assessment of patients on arrival. Your Ladyship will find this evidence from pages 47170 to 47172. Your Ladyship will recall that there were a vast number of affidavits that were handed in that had been made by Mrs. Mogosinyana in respect of each and every of the deceased covered by Mr. Profy's heads of argument. I'm not going to take your Ladyship through those affidavits. We will be here for the remainder of the day.
It's fine. I'll give them, yes.
They were from, I think, W1A onwards. I can't remember how many there were, my lady. But the important factor is none of them, not a single one, mentioned a lack of records or any difficulties related to records. Furthermore, none of them mentioned any difficulties experienced in the treatment of the identified users. As I've already said, my lady, she collected the documents and she described them, and I quote, prescription, letters and the form, everything that is in relation that we should come and collect. And that is on page 47757.
47757.
And the whole issue is covered from lines 5 to 18. And your Ladyship can perhaps just make a note that her specific answer to your Ladyship, confirming that all discharge reports had been received, is found at 46256, lines 23 to 24. A lady, she was asked by Mr. Profy, did you have any struggles or problems after you received these patients? And one would have expected her, given the arguments contained in Mr. Profy's heads, that she would have said, well, we didn't know how to treat these patients. But what she in fact said, and I quote, the challenge that we normally face would be they were used to smoking any time. But now at Mosega home, we had a certain time that we set aside for smoking breaks. Well, lady, that is the high point of the challenges that she says were experienced after the patients were received. They didn't comply with the smoking regulations. She confirmed that the patients were looking healthy, although old, frail, and some were wheelchair bound. And interestingly, my lady, when she was questioned in this regard, Mr. Profy objected, and he said, no, this relates to administration. And he said this witness was called in relation to the care she gave the patients and not the administration. So she is eminently qualified, if there were problems, to have confided in your Ladyship when asked to do so. When she was asked about concerns regarding the number of deaths, she didn't mention any factors that may have contributed. She was only concerned about the number. And your Ladyship will find this at page 47786. lines 5 to 6. I may perhaps mention Mr. Profi's intervention is at 47777, lines 3 to 5. Interestingly, my lady, she said in evidence that she kept the clinical records. She said she kept record of medicine administration. She testified that the notes of medicine administration were on another file that was kept separate and did not form part of the patient's file. And your ladyship will
Can I
find...
please, I think you are disrupting the proceedings. Please, when somebody's addressing the court, mute your mics. Continue.
Your ladyship will find that at pages 47788, lines 10 to 14, and 46157, lines 7 to 13, the latter pertaining specifically to the medicine administration file being kept separate from the patient's file. My lady, and I'm speculating now, that is perhaps why on the present dockets, prescriptions cannot be found. A separate file that was not copied, but that is speculation on my part. We know from Ms. Mokosinyana that she had testified that prescriptions had been received. Lady, Ms. Mokosinyana's evidence must be compared to that of Mrs. Mohoja and Dr. Sekukuni, who both emphasized that they were more involved with administrative issues and not so much with patient care. Mrs. Mohoja testified that she was not involved in the day-to-day care of patients. And when asked, she said that she was not in a position to comment on what caused the death of any particular patient at Mosego Home. And she, in response, and this was while being questioned by me, testified that she cannot implicate any person or entity in respect of the deaths. Your ladyship will find this at pages 46538, lines 1 to 13. Dr. Sekukuni, in turn, said that she did not directly work with mental health care users at Takalani. She said if a user was sick, she was taken to that user. And she testified she had no independent knowledge regarding the circumstances surrounding the deaths. She would be informed, or she would be as informed by the nursing manager or clinical service manager. Your ladyship will find this from page 46546 to 46547. My lady, she testified the care was very well. That's at 46547, lines 12 to 20. She did not make any mention of any adverse influences or concerns regarding patient care. One would have expected that, had it been the case. She was specifically asked, my lady, can you add to the circumstances surrounding the deaths? This is at 46546, line 22, to 46547, line 4. And her answer was, the only contribution that I could do is users were taken to local clinics and referred to district hospitals and Chris Hani Baragwanath. Now, my lady, Mrs. Mogosinyana did not raise concerns relating to records. On direct questioning as to any adverse aspects that may have impacted on patient care, both Mrs. Mogojwa and Dr. Sikakuni said they could not provide information and did not implicate anyone in the case of Mrs. Mogojwa. Lady, against that background, I briefly want to deal with the patients or users referred to in Mr. Profi's heads of argument from page 55313. Get to my notes. Leadership will bear with me. Thank you. The first patient is Mr. Johannes Longwane. To confirm something already. The attack on Life Esidimeni is that he had no prescription in his file and his periodic report was dated 2009. I've already dealt with the issue of the prescription. Mrs. Mogosinyana confirmed that prescriptions had been received. She didn't exclude any particular patient who may not have received. Lady, and just by way of example, I'm not going to do this in respect of each and every of these cases, but the same applies to each and every case. If I may refer your ladyship to case lines 14282. Ladyship will note that this is the Mosega Home admission assessment. It is fully completed. And if I may direct your ladyship to the heading in the middle of the page, roughly, MHCA admission forms, forms that residents submitted. It mentions MHCA 27 and 13A. But your ladyship will recall
yes,
that
I see this MHCA 27, 13 capital A.
As your ladyship pleases. But we know, my lady, that Mrs. Mogosinyana had confirmed to your ladyship on direct questioning that discharge reports had been received. So reference to the MHCA 03 is missing there. If your ladyship goes to the next page, the ladyship will note entries regarding vital signs, general appearance, mobility, self-care, dressing, feeding. The next page contains clinical information relating to, it says sight, but it should be insight, then orientation, behavioral problems, problem identified, but importantly, my lady, if one goes further, physical assessment, the diagnosis on page 14286, no family contact. There is no indication here, my lady, of an absence of information or a concern that they haven't received something which they ought to have received. All the sections are completed. Now, that could only have been obtained from the records provided by Life Esidimeni. Patient was not in a state to provide it. If your ladyship would turn to page 14289, your ladyship will note that this is it's headed monthly physical assessments. This was on the 18th of May 2016, which was shortly after the user arrived. He arrived on the 9th of May. And it includes assessment by a Dr. Syed A. Imran, a medical practitioner. And once again, my lady, one would have expected, if Dr. Imran had been concerned that he did not have sufficient information from the available records, that something would have been said about that. And that is also what, if memory serves me correct, Dr. Tala said he would have expected. Lady, if one then goes back to page 14287, this is dated the 5th of May 2016. New resident admitted from Randfontein Care Centre, fetched by, looks like RNM Mogosinyana with home care transport. And it describes his physical condition, it describes his psychological condition, and there is no reference to any lacking information. And then importantly, my lady, the next entries are on the 6th of May. Walks slowly, messes himself when eats slowly, can't make out something habits. And that's signed by Mrs. Mogosinyana on the 7th of May. Mr. Dlongwane is aging. I don't know if it's faulty habits. Needs supervision. That was scratched out. Needs some assistance during bathing. Untidy, eats slowly and messes himself. Also signed by Mrs. Mogosinyana. And then on the 12th of June 2016, patient not waking up and not responding to his name. cold on touch. At 0500, his vital signs were taken. Blood pressure 60/49, pulse was feeble. And onto the next page, respiration very slow as if tired. Sister Mogosinyana informed, said patient to be washed and kept warm. And it's signed by Mrs. Mogosinyana. My lady, the patient who is not waking up and not responding, who has a blood pressure of 60/49 and a feeble pulse, is a patient who is decidedly unwell. And to be washed and kept warm, I think, is the least of what should be done. He needs medical assistance to determine what is going on. And at 0605, patient gasping while being washed on bed, no pulse felt. And at 0610, no respiration, deceased at 0610, Sister Mogosinyana informed, then last officers done. Lady, the allegation is patient care was impacted by lack of records. Where is there any indication, and these are the only available records from Mosego regarding the late Mr. Dlongwane, where is any indication that there are difficulties in caring for him, or that they don't know how to care for him? It doesn't exist. And what is of concern, my lady, is if one looks at the gap between the note of 7 May 2016 and the one of 12 June 2016, we don't know what happened there. There's no indication of what the late Mr. Dlongwane's condition was, whether he was stable, whether he was improving, whether he was deteriorating, nothing. We just have this sudden, out of the blue entry on the 12th of June 2016, which is the date on which he passed away. And just in that regard, my lady, I may have misheard Mr. Profi, but he said that the date of death was 12 May 2016. It's 12 June 2016. My lady, and I can take your ladyship through each and every of these patients. And the pattern is the same. No indication on admission that there is any concern about lack of records or lack of information. No indication in any subsequent entry. And usually an entry suddenly and without any indication that any change was in the air, that the patient had deteriorated and died. Lady, and perhaps just to drive home the point of that I made earlier, that the admission assessment document does not refer to the form MHCA03. If your ladyship will turn to page 14290, that is the discharge report, MHCA03. A very detailed document giving a full history, a full diagnosis, and information regarding treatment. And as Dr. Talatala said, that was sufficient. Let me get his words. that summary that we discussed earlier on of the important things to include, that is all. I mean, that can go a long way. And this demonstrates it, my lady. There should have been no misunderstanding as to how Mr. Dlongwane was to be treated. And to allege that his care was compromised by an outdated periodical, which is a document which need not have been provided, has no basis whatsoever. My lady, if I may turn to, just once again, by way of example, page 55316, paragraph 18.7. It's docket 94, Mr. Matthijs Hartman. Mr. Profi said he was received on 6 May 2016. He passed away on 29 August 2016, so almost 3 months later, 2.5 plus months later. And he again raises an outdated periodic report, which is a document which need not have been provided. And he made the following submission to your ladyship. He said that given the short period between arrival and death, I'm paraphrasing, it is clear that the lack of medical records hampered care. Now, my lady, that is a leap of logic that I fail to understand. Because if that were indeed correct, then all of these patients should have died within a few days or weeks from arrival, if lack of records caused death. And it shows the fallacy of the arguments by Mr. Profi. And one can look at Mr. Hartman's case. He was 57 years old. He had been at Life Esidimeni more than 5 years, almost 6 years. His discharge report, my lady, can be found at case lines 6454.
Six five 6454.
54, my lady. His assessment report, the Mosego assessment report, can be found at 6384. And it shows the same pattern, my lady, as that of Mr. Dlongwane. Once again, under the MHCA admission forms, it doesn't mention the MHCA 03. On page 6385, we once again see an examination report by Dr. Imran, which does not raise any concerns. On page 6386, there is an admission entry which reads, new resident admitted from Randfontein Care Centre, fetched by Sister Mogosinyana using Mosego home transport. Physical, Mr. Hartman is well hydrated, eats well, no physical ailment seen. Psychological, orientated to place, time, not person. Clean, needs minimum supervision, assist in household chores. Social, no family seen yet. And then there are entries. An entry on 17 May, went to local clinic, seen by doctor. User to continue treatment. And on the 11th of June, an entry, 10 July, 7 August. Now, the June and July entries show no concern about lack of records or uncertainty about treatment. But what happened, my lady, on the 7th of August? It's recorded patient has a septic wound on right buttock. Sent to local clinic to be examined by doctor. Well, we know he didn't have that septic wound when he arrived from Life Esidimeni. We don't exactly know what happened at the hospital, but the next entry on page 6387, on 29 August, now this is 3 weeks later, patient not well on Sunday the 28th afternoon, nurse on duty, checked vital datas, not heard, restless, fluids pushed, refusing to be touched. Night nurses took over, they also checked vital datas, not registering. My lady, this is now vital data that could not be detected during the day, on the Sunday. Now the next day, still can't be detected. Took patient to hospital after assessment at 2110. Patient admitted at Helen Joseph Hospital, no beds in Leratong. Mrs. Mogoja notified about death. Now, my lady, if one looks at the entry in the Helen Joseph Hospital records, I refer your ladyship to case lines 6407. It's difficult to read, my lady. I'll transcribe it. It reads, a new 58 years old male patient admitted in Ward 9. Came accompanied by porter and nurse via casualty on stretcher. Condition clinically appears chronically unwell. Plus. So extremely unwell chronically. Continues, unresponsive, connected on polymask oxygen, came with drip in situ on Ringer's lactate and adrenaline, not running. Main complaint, according to casualty, noted he came complaining of hypoglycemia, known asthmatic and known diabetic. He was brought by escort and paramedics from Mosego home-based care. My lady, I'm not going to take your ladyship through the entire records, but what is worrying is that at the examination, and your lady will find that at 6441, that's Dr. Shakira Holland. He performed a medico-legal post-mortem examination on 22 September 2016. And under her chief post-mortem findings, which your ladyship will find under Roman paragraph 4 on that page, she says, body of a Caucasian adult male with a history of being hospitalized at the Helen Joseph Hospital from 28 August 2016 to 0220 on the 29th August 2016. The deceased had been living in a care facility before admission to Helen Joseph Hospital due to having a psychiatric illness, which was stated as schizophrenia. He was referred to Helen Joseph Hospital because of the onset of an acute medical illness. At the Helen Joseph Hospital, the working diagnosis was of pneumonia with septic shock and a possible cerebral vascular accident. On admission, the deceased was wasted and had a grade 3 decubitus ulcer, a bed sore. Investigations showed septicemia. Haemophilus influenzae was identified on blood culture. And then the post-mortem examination showed bronchopneumonia complicated by acute respiratory distress syndrome, a scaling macular-papular rash over the body. There were features suggestive of chronic neglect which need to be further investigated. Wasting, body mass index of 17.3, decubitus ulcers of the left temporal area on the head, and the right buttock, which showed features of sepsis. The fingernails and toenails were long and dirty. And the cause of death, bronchopneumonia complicated by acute respiratory distress syndrome. Features of chronic neglect must be investigated. Now, my lady, with respect, how did a lack of information from Life Esidimeni cause the wasting, the formation of bed sores, and bronchopneumonia? And it is for that reason, my lady, that I said at the outset that the allegations made against Life Esidimeni are speculative, devoid of fact, and lacking logic. Lady, I'm going to take your ladyship to only one more of these, and that is Rebecca Schlabati, paragraph 18.12 on
I see it's 6 minutes before 1 o'clock. Do you want to proceed now or?
Lady, I think I'll be able to finish with her before 1 o'clock.
Okay.
I may go a minute or two over.
It's 18.12.
As your ladyship pleases.
Mm.
Now, my lady, this is a user who was 87 years old. She had been at Life Esidimeni for more than 32 years, looked after successfully. The allegation is the user had a heart condition. She came without medication for her heart, which medication is required on a consistent basis. Such an oversight would interrupt the care the NGO would provide to the user. Lady, I don't know who suggested that she had been on medication and required medication at the time. But I wish to refer your ladyship to case lines 15936.
One 5936.
As your ladyship pleases.
Mm.
My lady, I'm not going to. This is the form MHCA03, the discharge report from Life Esidimeni. Your ladyship will see it is complete. And in the lower right-hand corner is the diagnosis that is made in terms of what is known the DSM-5 categories, where there are 5 aspects that are relevant. And the third axis relates to a history, a medical history, not a current history. Axis 1, which is marked with a Roman numeral 1 here, chronic schizophrenia, dementia. That is what she was suffering from at the time. Axis 2, I must confess I can't remember what that relates to, but axis 3 is medical history. And it says history of CCF, congestive cardiac failure. This patient had a history of it, but she did not suffer from it at the time. She had not been treated at Life Esidimeni for congestive cardiac failure. Hence, no medication was provided. And yet, my lady, Life Esidimeni managed to keep her going for 32 years. But Mr. Profi would have one believe that she died within approximately 3 weeks at Mosega home because she did not have medication for congestive cardiac failure. There is no factual basis for the allegation, my lady. Once again, it is speculative and devoid of a factual basis.
Yes.
And just for completeness, my lady, your lady will find on page 15955 the physical examination report from Life Esidimeni. Your ladyship need not go there. I'm just mentioning it so your lady can make a note of it. A periodical report of 8 May 2015 at page 15956. And a prescription.
Just a second.
My apologies.
What is the page for the periodical report?
15956.
Yes, okay.
And a prescription at 15973.
Okay, thank you.
Lady, I see I made it with 1 minute to spare. Can I continue adjournment?
In that case, we'll take the lunch adjournment and we'll resume at 2 o'clock. Thank you.
As your ladyship pleases.
May it please the court, my lady.
We have now reconstituted after the lunch adjournment. Mr. van Bergen.
Thank you, my lady. My lady, I don't intend taking too much time up further. I just want to refer your ladyship to one or two more of these cases. And the first one is Mr. Jonathan Motapo. Your ladyship will find the reference to him in, I'm sorry, I must just quickly find it. It's paragraph 18.11 on page 55316.
Yes, I'm there.
The allegation is there was no periodic report. My lady, as I've indicated, periodic report is not required. It was a supplementary document provided. But purely for comparison purposes with the last case that I dealt with before the lunch adjournment, that of Mrs. Rebecca Slabati, who had a history of congestive cardiac failure, may I refer your ladyship to page 14214.
14214.
As your ladyship pleases.
Yes, proceed.
Your ladyship will note with respect that this is the MHCA 03 discharge report. If I may refer your ladyship again to the bottom right-hand corner.
Yes.
Your ladyship will note the Roman numeral 3, CCF, so that's again congestive cardiac failure. Stable on RX, stable on treatment. RX is an abbreviation for treatment. Your ladyship will recall that in the case of the late Ms. Slabati, it said history of CCF. So the two show the difference, where one is purely a history of a condition and the other where the condition is in fact suffered at that time. And your ladyship will note in the left-hand column items 4, 5, and 6. That's Lasix, Slow K, and Digoxin. That is treatment for congestive cardiac failure.
Okay.
So just by way of comparison, demonstrating that Ms. Slabati's condition was purely a history and not a current condition. My lady, the next case is that of Mr. David Mabati. That's
just a second. Yes, Mr. David Mabati.
Mabati, he's paragraph 18.10, my lady.
Yes.
My lady, the allegation is made that he had no medication in respect of TB. Now, the facts are that he was admitted on the 10th of May, 2016. I'm not going to go through the whole history, my lady. I'm only going to deal.
Just yes.
The records, he was referred to the Dr. Yusuf Dadu Hospital, and the relevant records can be found on case lines 14697 to 4699.
Yes.
And he was treated at that hospital on 29 September 2016 for a corn on his small toe and an aphthous ulcer on his lower lip. Maybe just for transcribing purposes, aphthous is APHTHOUS. But the important thing is that on that date, a tuberculosis screen was performed on him at the hospital, which was negative. So he did not have tuberculosis.
Where do you get that?
My lady, that is in the records of the hospital at the reference I provided, 14697 to 4699. My lady, he was readmitted to that hospital on 6 January 2017. And then he was suspected to be suffering from multi-drug resistant tuberculosis. And your ladyship will find that at 14713. He did not have tuberculosis, life Esidimeni. Lady, I would submit that it's not necessary to go through each and every of the other ones. The allegation made is either there was no prescription or there was a periodical that was outdated. Thank you, my lady. Those are the main allegations. We know that prescriptions were provided. That was confirmed by Mrs. Mogosinyana. The periodical report is a supplementary document that is not required in terms of the Mental Health Care Act, and it would have assisted in treatment, not detracted from treatment. My lady, your ladyship will recall that a number of these cases were dealt with in evidence by Dr. Mkachwa, both under cross-examination by Mr. Profi and re-examination by me. And the re-examination, your ladyship can find at 47946.
47946.
As your ladyship pleases, to 47959. Now, my lady, unfortunately, it seems that there was a problem with the transcribing and much of the evidence was not recorded or transcribed. But the gist can be found, and it corresponds with what I've taken your ladyship through. Your ladyship may perhaps recall that the next witness that testified was Dr. Sekukuni. I'm speaking under correction, but when Dr. Sekukuni testified, Mr. Profi commenced asking her questions about periodical reports and the requirements of the Mental Health Care Act in respect of periodical reports. And your ladyship at that point interrupted Mr. Profi, and your ladyship will find that at 46554, lines 10 to 15. And your ladyship said inter alia, given the evidence that we heard yesterday, and that's referring to Dr. Mkachwa's evidence, regarding the fact that whatever they received, according to Dr. Mkachwa, would not have disabled them to continue with the further treatment of the patients. And your ladyship then asked about, well, it related to what was the relevance of the periodical reports. But that mention by your ladyship of what Dr. Mkhatshwa had testified and what it had indicated provides some idea with respect to your ladyship of what the gist of Dr. Mkhatshwa's evidence, not all of which has been transcribed. And that aspect, my lady, is the issue of dealing with the periodical reports and requirements of the Mental Health Care Act is relevant to the argument raised by Mr. Profi that because outdated periodical reports do not comply with the Mental Health Care Act, a finding in terms of Section 16(2)(d) of the Inquest Act should be made against Life Esidimeni. That was what was stated in the heads of argument. Today, Mr. Profi suggested, or not suggested, he said that such a finding should be made against Dr. Mkhatshwa personally. The debate that followed when an objection was raised to Mr. Profi debating periodical reports and the requirements of the Mental Health Care Act with Dr. Sekukuni followed, and your ladyship will find this I must just find the reference. I think it follows. Can I just have a moment to make sure?
Okay.
Yes, if your ladyship were to have regard, your ladyship says at line 10, well, where are we getting with this, given the evidence that we had yesterday regarding the fact that whatever they received, according to Dr. Mkhatshwa, would not have disabled them to continue with the treatment of the patients. And Mr. Profi said, correct, my lady, but the buck stops at, in terms of the Act, that is the purposes for why it needs to be up to date. And your ladyship said, well, all right, she can just answer. And then Ms. Marriott raised her hand, and she said, it is my respectful submission that this does not take the issue pertaining to causality any further. I do not see the relevance. And I then, on the next page, my lady, approximately line 6, I said, my lady, it goes back to the individualization of cases. It does not help to make blanket, sweeping statements without indicating that the deficiency that one complains of has caused the death of or contributed to the death of a specific patient. So unless Mr. Profi intends doing that, I submit that this line should not be allowed. And then ultimately, your ladyship ruled, and that is line 16, where your ladyship said, yes, in my view, the question is not allowed. And I submit that the same considerations apply here, my lady. A contravention of the Mental Health Care Act relating to alleged deficiencies in documentation plays no part in an inquest, unless it can be shown that there is a causal relationship between such deficiency and the death of a particular patient. I therefore submit, my lady, that the argument by Mr. Profi that deficiencies in periodical reports, because they are outdated, provides a factual reason for a finding in terms of Section 16(2)(d) can only be correct if there is proof that such deficiencies caused a death. And there are two aspects there, my lady. The first is, as I've indicated, periodical reports are not mandatory documents in a transfer. And secondly, my lady, Mr. Profey has not provided one iota of evidence showing how any deficient or outdated periodical report caused the death of any particular patient. For example, my lady, Mr. Sam said that his periodical report was outdated, but Mr. Sam, an 80-year-old person, fell, bumped his head, suffered a fractured shoulder, and passed away from a cerebral bleed. How on earth is that related to a periodical report that is outdated? And I can go through each and every of the cases, my lady. There is no such causal relationship. Lady, my learned friend, Mr. Profey, in paragraph 27.9 and 27.10 on page 55324 of his heads, makes the allegation that it is not in dispute that LE held back the medical records of the patients.
Yes, now paragraphs 27.9,
my lady.
Okay.
And in 27.10, he refers to LE's refusal or inability to provide complete clinical records. My lady, that was not the evidence at any stage, and Mr. Profey knows it. There was no requirement to have provided the complete medical records, and I've already addressed that. And it was confirmed by Dr. Talatala, amongst others. To twist evidence in this fashion is uncalled for. My lady, I submit against the background of what I've addressed to your ladyship that Mr. Profey, on behalf of his clients, did not provide any credible and acceptable evidence on which could prove that death of any deceased was caused by a culpable failure to have provided any required records or information. And more particularly, my lady, no finding of such nature can be made against Dr. Mkhatshwa. In fact, my lady, I would submit that such an argument when viewed against Dr. Mkhatshwa's conduct throughout the sad history of this matter, is irresponsible. This is the person who had at the outset warned the Gauteng Department of Health of the risks inherent in the manner in which they wished to transfer patients. His organization, the one that he was the managing director of, Life Esidimeni, was compelled in terms of a court order to transfer the patients, the order of Mr. Justice Valley. He warned against the background of the previous transfer in 2007 of children who had died, that the consequences could be disastrous. He was ignored. He was promised, as were other people, that the mental health care users would be transferred to facilities equal to or better than Life Esidimeni.
Just before you continue, let me get you clear regarding this point that I didn't pick that up. If you can just rephrase regarding the judgment by
as your ladyship pleases.
Mr. Bailey, yes.
It was suggested that Life Esidimeni should not have agreed to transfer the patients.
Okay.
The fact is there was a court order in the application brought by SADAG, amongst others, in terms of which the transfer was or got judicial the go-ahead. Life Esidimeni couldn't refuse to transfer patients. The contract had been terminated lawfully with proper notice. They had no grounds upon which they could refuse to pay not to transfer the patients. And what I'm addressing your ladyship on is the background against which this argument by Mr. Profi that Dr. Mkachwa should or is deserving of a finding in terms of section 16(2)(d) is wholly inappropriate. Dr. Mkachwa, as I said, warned people by name, Dr. Manamela, and others at the Mental Health Directorate, that disastrous consequences may flow from the steps that they were taking. He insisted on, but was refused, participation in the vetting of NGOs. He insisted on being provided with a detailed decantment plan or transfer plan. He was only in April 2016 provided with a plan which mentioned only the numbers of patients and the dates on which those patients were to be transferred. He arranged the safeguard of having clinicians at the facilities to whom users were transferred. And he arranged a method with Dr. Manamela in terms of which records could be copied by the Gauteng Department of Health. My lady, if any one person did his level best to prevent what eventually happened, it was Dr. Mkachwa. And he is certainly not deserving of the argument that Mr. Profi made to your ladyship. There's no basis for a finding, as is suggested by Mr. Profi. And I submit, my lady, that such a finding must be refused. My lady, unless there is anything else that your ladyship wishes to hear from me, that is my argument.
Yes.
As your ladyship pleases.
Thank you. Mr. Pinar, are you ready?
May it please the court, my lady? I am ready to proceed.
Yes, you may proceed.
Or to commence, at least.
What is happening with your photo?
Sorry, my lady, I was kicked out, but I'm back, it appears.
Oh, there you are. Yes, you may proceed, Mr. Pina.
May it please the court, my lady. I'm indebted to your ladyship for the indulgence to only commence today with my, as in terms of the roster, with my submissions to your ladyship. My ladyship, I've listened attentively to my learned friend, Mr. van Bergen's introduction in his submissions to your ladyship, and I wish to intimate that I concur with the submissions made regarding onus, except for the fact, my lady, that I respectfully submit that the onus as applied by the High Courts in the United Kingdom of England is deemed not to be acceptable, my lady, and I will submit as follows in this regard, my lady. I respectfully submit, my lady, that regarding the onus or burden of proof, I respectfully submit that I believe this problem has been created by the provisions of section 16(2)(d) of the Inquest Act 58 of 1959 as amended, and I quote, with your ladyship's permission, the judicial officer holding such inquest shall record a finding accordingly, and thereupon the provisions of section 2 shall apply, and then I refer to subsection 2 between brackets D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offence on the part of any person. My lady, that creates the impression there is a burden of proof that has to be met.
Mm.
And of course, the counter side of that is then there would be a burden of rebuttal on a party that's been involved to a certain extent. My lady, but my submission is, and I believe I respectfully submit that the wording contained in subsection D of section 16(2) led to the impression and resulted in a situation where parties involved in this inquest felt that they had to present proof of whatsoever nature, because in order to acquit them of their burden of proof. And my lady, my submission is, with all due respect, that this was a further reason why, and with due respect to the learned evidence leaders, and I believe they were correct, that these inquest proceedings are not criminal proceedings, therefore cross-examination extensively, which may be relevant in a criminal matter, is not relevant in an inquest and should therefore not be submitted. My lady, if we have regard to the process or the procedure of an inquest, and especially an inquest of this magnitude, my lady. It's my respectful submission that regard should be had to the nature of an inquest. It's quite clear, my lady. I respectfully submit that an inquest is not adversarial in nature, as in a criminal matter, nor is it adversarial as in a civil matter.
Yes.
The nature, I respectfully submit, my lady, is it is inquisitorial. It is an inquisitorial process managed by the judicial officer presiding at such inquest. In this instance, my lady, it was yourself, my lady, who was in control of this inquest and of the inquisitorial nature and process that had to be followed. My lady, once it is accepted that an inquest is an inquisitorial process, it is my respectful submission. Burden of proof, as we know it, generally speaking, in terms of the law of evidence, does not apply to inquest proceedings. I'm well aware, my lady, with respect of the judgment handed down by your brother, Judge Motley, in the reopened inquest in the matter of Rodriguez in the Gauteng High Court, Johannesburg, earlier this year, in which Judge Motley, with all due respect, confirmed that inquest proceedings are not criminal proceedings nor civil proceedings, although they may in a certain instance, if regard is had to Section 8, subsection 2 of the Inquest Act 58 of 1959, as amended, more akin to a criminal process, it is not criminal proceedings, my lady. But clearly inquisitorial. And my submission, therefore, with all respect, my lady, to everybody involved in this inquest is that we emanated from the situation, except, and I say that with due regard to the evidence leaders for them, that there was a burden of proof upon each of the parties to prove or to present evidence undoubtedly indicative thereof that one or other party was prima facie responsible for the 144 deaths that had ensued. That premise, I respectfully submit, my lady, is incorrect. The burden of proof, between inverted commas, if I may refer to it as such, my lady, is no more than a requirement that at the conclusion of all the evidence, your ladyship, as the presiding judicial officer, had deemed expedient and necessary to conduct this inquest, concludes, having heard the evidence, and my lady, in this regard, not only having heard the evidence, but having evaluated the evidence. And when evaluating the evidence, of necessity, your ladyship is called upon to consider the merits and the demerits in the witnesses that were called evidence, insofar as it may be applicable. And only in that sense, my lady, do I submit, may credibility play a role, not an overriding factor nor role, but it's one of the factors to be placed on the scales to evaluate the evidence together with its merits and demerits, whereby, of course, is included the probabilities and improbabilities inherent in each witness's evidence that was presented, my lady. So I would submit, my lady, it's not, I do say, my lady, and I'm submitting this with all due respect, and it's also applicable to myself, my lady, with hindsight. I also erred in this regard by submitting to your ladyship that the evidence is of such a nature that it prima facie proves that a particular party or entity involved in the marathon project was responsible by their conduct or even by means of an omission to act, and therefore such parties are prima facie responsible for the subsequent consequences, which were the demise of 144 mental health care users. My lady,
I'm listening.
may it please the court, my lady. My learned friend, Mr. van Bergen, referred to the matter of Gonive, wherein the court concluded that the burden of proof is not the proof beyond reasonable doubt, but a burden which is much less stringent, my lady. And being less stringent, all that's required of the judicial officer is that he or she who's presiding at an inquest must be of the opinion that there is evidence available which may at a subsequent criminal trial be held to be credible and acceptable. My lady, there is no requirement that your ladyship must be convinced. It's an opinion your ladyship must arrive at, having considered and evaluated all the evidence presented.
Mm.
And then, my lady, it's not for an inquest court to decide has such or such or such a crime been committed, be it murder, be it culpable homicide, etc., my lady. Only an opinion that evidence, that there is evidence available which may, not which would, not which will, only may, my lady, at a subsequent criminal trial be held, not it will be held or will be concluded, will be held to be credible and acceptable, and which, if accepted, not it will be accepted, there's no such requirement, only if accepted, could prove that the death of the deceased was brought about by an act or omission which involves or amounts to the commission of a criminal offence on the part of the person or persons involved. Lady, this is a much less stringent consideration and conclusion which your lady is asked or called upon to arrive at the end of the day. My lady, I've listened, and as I've indicated, I erred in the same manner, my lady. But having the advantage of hindsight and keeping in mind errare humanus est, it's human to err, my lady. I've decided and submit that it is proper for me to present a situation legally which is acceptable and which is in accordance with judicial decisions that have already been handed down by the High Court in South Africa. And I believe, my lady, that alleviates a lot of the submissions that have been presented to your ladyship, which all require of your ladyship to make a positive, conclusive finding that A or B, due to an omission to act or a specific act, is therefore causally linked to the consequence, the demise of the 144 mental health care users. The lady, whilst that is not the test, that's not is required to do in terms of the Inquest Act. And the reason for this is quite clear, my lady. An inquest is not a criminal matter. So, for one, cross-examination is limited in an inquest. And I need not repeat, there were many instances where cross-examination was disallowed on the basis of being irrelevant, which was correct, my lady. But, and the reason for that, my lady, once more, I submit with respect, is to be found in the fact that your ladyship is only required to form an opinion, but not an opinion that's conclusive, my lady. An opinion founded thereon that there may be evidence, should there be criminal prosecution, that may, not will or must, but may prove the commission of an offence.
If I may, by so saying, are you therefore retracting what you have just said in your heads of argument?
My lady, I will. I was at the end of my address to your ladyship. I will formally retract certain of the paragraphs I made in my heads of argument on, and that's why I'm addressing your ladyship from the initial point
Okay,
with regard
that's fine.
in this manner, my lady.
You have made your point. Let's not repeat what we've just
Thank you, my
submitted,
lady. I'm
please.
indebted to your ladyship.
Yes.
My ladyship, if I may at this stage, maybe it's more, with your ladyship's permission, if the court would just bear with me for a minute, my lady. I want to get the specific. My lady, before I venture to that, sorry.
Sorry, my lady, if I can just assist my senior.
Yes.
This Advocate Sibara, maybe difficulties with my camera. Perhaps my senior is for page 55283, paragraph 9.2. That is the paragraph which deals specifically. Court, my lady, thank you. On case lines 55283, paragraph 9.2 of his heads of argument.
May it please the court, my lady, I'm indebted to Mr. Sibara on page 55278, my lady, as it's, but that would be paragraph 5.3 of my heads, my lady.
Okay, yes.
And I said further submissions presented to this Honourable Inquest Court is founded on the proposition that this Honourable Inquest Court's final ruling on admissibility it's not all, may be to rule that the arbitration proceedings are admissible as prima facie proof of the content thereof. Lady, this is an additional issue I will be returning to. But
okay.
If I may refer to page 55281, and that is paragraph 8. The lady, once again, paragraph 8.3 then also becomes qualified. It is to be noted that the requirements on civil liability does not consist only of conduct that was negligent, it also includes palata, gross negligence, which borders and founds the principle of dolus eventualis being applicable. This is not, I would submit, applicable at this stage, my lady. And furthermore, my lady, on page 55283, that would be paragraph 9.2. The officials at the time subsequent to the termination of the Life Esidimeni service level agreement and the subsequent transfer of mental health care users to NGOs or other facilities without complying with the prescribed requirements and protocols are prima facie criminally liable and stand to be arraigned in a criminal court. Lady, that's not correct. That's not what your ladyship is called upon to do in this matter, my lady. Unless any of the parties had voluntarily confessed to being liable, which is not the case, my lady. And then paragraph 9.3, my lady, I referred references made on the same page to
Just a second. Yes, what is the next page after 9.2 on page?
Same page, page 55283, my lady.
Yes.
Paragraph 9.3, I referred to the specific officials.
Yes.
My lady, at most, your ladyship is called upon to conclude and make a ruling in accordance with the opinion your ladyship has reached with regard to these officials after having evaluated all the evidence, my lady.
Mm.
Then, my lady, for the sake of clarity and completeness, on page 55291,
Yes.
in paragraph 14.1,
Mm.
my lady, the conclusion once more set out there is then to be considered in the light of the submissions regarding proof that are made to your ladyship.
Mm.
My lady, the second issue I'd like to traverse is regarding the arbitration proceedings.
Yes.
Your ladyship handed down a provisional ruling that the arbitration proceedings are admissible, with a final ruling to be handed down at the conclusion of the inquest.
Is that what I said?
My lady, that's I
As far
understood
as
it.
I don't know how you understood it, because
Well,
I said at that stage, I felt that there was no need for me to give that ruling, because the issues that were raised, I felt that there are issues that will be dealt with the totality of the evidence.
sorry, my lady, then I misconstrued your
I hope the others
ladyship's
also
ruling.
understood me the same way.
No, sorry, my lady, then I will accept. And I apologize, therefore, my lady. I was under the impression it was only admitted provisionally. But nonetheless, my lady, of course, the submissions I've made in my heads regarding the arbitration proceedings will
Yes.
then not be applicable, my lady.
Okay.
Except to state the fact that admissions made in the arbitration remain admissions to be considered when evaluating the evidence. So the evidence is not to be evaluated in vacua, but together with the admissions made, be they to the merit of a witness or demerit of a witness, they must still be considered and evaluated as it pleases the court, my lady.
Okay.
And the fact that admissions were made in judicial proceedings, and I submit the arbitration proceedings were judicial proceedings,
Yes.
that are civil in nature, does not result in such admissions being ignored in any later or subsequent judicial proceedings, such as this inquest, my lady. And such admissions can be considered in terms of the fact that your ladyship must evaluate and conclude and reach an opinion in that regard, my lady. The fact remains those admissions, although made in other judicial proceedings which are civil in nature, can still be utilized in subsequent criminal proceedings. So they remain relevant and a factor to be considered.
Yes, continue.
My lady, the last issue I'd like to refer to is there were serious complaints raised regarding my or the heads of argument presented on the behalf of Ms. Hannah Jacobus, sequential witness number 8. Whilst not specifically dealing with the nature of Ms. Jacobus's evidence as presented at the arbitration, which she confirmed at this honourable inquest. My lady, in this regard, my submission is she credibly admitted to the evidence that had been elicited from her during the arbitration proceedings. But there's one qualification, and that is Ms. Jacobus, and this must be kept in mind, my lady, although being a deputy director in the Gauteng Mental Health Department,
Directorate, yes.
Or director, thank you, my lady, I'm indebted to your ladyship. Her evidence was, and that was not disputed, that she experienced problems, Dr. Manamela, due to the haste of the marathon project in which it was being put into operation. To such an extent, my lady, that she was regarded as being meddlesome by Dr. Manamela for the fears and concerns she raised. That the process was too hasty. It would be to the detriment of mental health care users. And what was the result, my lady? Dr. Manamela, being her superior, for all practical purposes, demoted Ms. Jacobus and promoted Mr. Frank Tobani to be her second in charge. And the evidence that Ms. Hannah Jacobus also presented, my lady, and this came out at the arbitration, was that she was instructed not to communicate directly with Dr. Manamela, but it had to be via Mr. Frank Tobani. He was the one to report to Dr. Manamela. This,
Yes.
be it animosity between Dr. Manamela and Ms. Hannah Jacobus, or be it an irritation with her continued objection to the implementation of the marathon project, she was directed and ordered not to return to her office, but she was instructed to find available beds and linen. She became, for all practical purposes, a bed and linen lady. And this continued, with all due respect, my lady, until the completion of the marathon project on the 30th of June 2016. I would respectfully submit, my lady, that if this state of affairs is kept in mind, it is quite clear that there is not evidence indicative thereof and of such a nature for your ladyship to conclude and find, or rule rather, that Ms. Hannah Jacobus's conduct justifies an opinion that there may be evidence at a later stage should there be a criminal prosecution which could possibly prove that she had committed an act or an omission that was criminal in nature, leading to criminal liability.
Mm.
The lady, then a further issue that was directed at myself and, if I remember correctly, Miss Phyllis Foster on behalf of the 4 families, is that my client, Miss Hannah Jacobus, or myself, Tabonis Proprius, should be mulcted with a cost order, my lady. I do not, well, I would inquire from your lady, does your lady respect or expect me to formally respond to that, lady?
Well, it's up to you, but
The
it's
lady,
up
with
to
all
you
due
because-
respect, I would submit such a request is not founded, my lady. More so, if regard is had to the fact that this inquest proceeded on the premises that parties were called upon to indicate that a party had acted or failed to act, and therefore prima facie involving or amounting to an offence, which is not what your ladyship is required to find, my lady, notwithstanding the language used as it's been already determined by our courts, my lady.
Mm.
And therefore, I
has he frozen or what is happening?
It seems like, my lady, even on my side, is frozen.
Please try to alert him or whoever can be able to do that. Where is Mr. Shabangu? Is he there? He should be in the same vicinity. Mr. Shabangu, are you there to assist us? Or any one of you can phone him?
Lady, am I audible to yourself?
Yes, but you seemed to have been frozen.
Yes, my lady, and I was kicked out. I've lost connectivity.
Oh.
But
You can take it from there because we didn't pick up what you have just said now.
My lady, at no stage, and I say with all due respect, was cross-examination of any of the witnesses conducted in a manner to unnecessarily extend this inquest, my lady. Nor was cross-examination in any manner conducted in a manner that was vexatious or derogatory of any of the witnesses. And nor were my heads of argument presented in vacua but founded on the evidence presented as well as the admissions made by the particular witnesses at the arbitration. Which I submit, my lady, is not improper and was justified. To a large extent, it was founded on the error I made regarding the burden of proof and what was required of your ladyship as the presiding judicial officer at an inquest, my lady, which I have admitted I had made and for which I tender, insofar as appropriate, my apologies to any of my colleagues who may have been misled as a regard of that fact, my lady.
Okay, anything else?
My lady, sorry, my lady, I've just lost a bit of track now, but if your ladyship would just indulge with me or grant me a moment, my lady.
Okay, that's fine.
I beg the court to bear with me, my lady. My lady, in conclusion, my lady, I respectfully submit that sorry, my lady, now I've remembered an issue that slipped my mind. Lady, one more issue I would like to refer to is the fact, my lady, that Mr. Mosunogi was the project leader. Dr. Manamela was the deputy project leader. Ms. Hannah Jacobus was never a project leader in any manner whatsoever. Dr. Celebano was the head of the department. And by manner of speech, he was the captain of the ship, my lady. Together with the acting Director General at that stage, later Director General, Dr. Lebete. But No evidence has been presented by any of these officials that a program was devised to implement the marathon project with checks and balances. To assist in the logistics of the project and to alleviate as far as possible and to address the fears and concerns that had been raised, not only by members of the Health Directorate itself, but also by private practitioners who were experts in the field of psychiatry and dealing with mental health care users, which is the common cause, my lady, is the most frail and vulnerable portion of our community. And then one last issue, my lady, was also that I am propagating a war crime that's been committed. That's not correct, my lady. Nowhere did I refer to a war crime. And in any case, we're not involved in a war as far as I'm aware. But nonetheless, I referred to a crime against humanity, my lady. And here the words of the Honourable Deputy Chief Justice, previous as then the Honourable Judge Moseneke, made reference to mental health care users being tortured or subjected to torture in this process. My lady, that's a severe statement or indictment, and that was never denied by any of these officials, my lady. My lady, that, sorry for the, concludes my submissions to your ladyship. I would, in the premises, respectfully submit, my lady, that applying the test that your ladyship required to apply in order to arrive at and make a ruling in your ladyship's opinion, which is justified, I would submit such a ruling would be justified with regard to the officials that I have referred to in my heads of argument, but only for purposes of the opinion your ladyship is obliged and called upon to present. And should criminal proceedings ensue at a later stage, where thorough cross-examination is admitted to properly and decisively ventilate issues such may at a criminal trial be held to be credible and acceptable, then it may lead to or result in a finding by the criminal court, but not by your ladyship, my lady. Only in support of the opinion you are called upon to present, my lady, and hand down. That concludes my submissions to your ladyship, unless your ladyship wants to hear me on a specific issue.
No, for now, no. Mr. Sibara, I see there is a hand there. Thank you, Mr.
Lady. I see I beat my time.
sorry, my lady, before my senior could go away,
Okay.
I just want him to be specific because this would spare the court's time extensively on our side. What is he saying about his submissions on paragraph 9.3.3 of his sense of arguments, which is on page 55283? Because he's
in paragraph 9.3, and you can also explain 9.3 for 9.3.3.
Milady, 9.2, paragraph 9.2 on page 55283.
Yes.
I made the statement. Submitted. The officials at the time subsequent to determination of the Life Esidimeni service level agreement and a subsequent transfer of mental health care users to NGOs or other facilities without complying with the prescribed requirements and protocols are prima facie criminally liable and stand to be arraigned in a criminal court.
Yes.
Milady,
you have submitted that. That is incorrect.
I withdraw that statement. I do not, at this stage, in my conclusion, say they must be arraigned. These are the officials. They are referred to in paragraph 9.3. My submission is there are grounds. Your ladyship is not called upon to refer anybody to a criminal trial, my lady, to be arraigned.
Okay.
Your ladyship is required to form an opinion, my lady. No more than that, my lady. With the further rider, if I may refer to it as such, that the factor in arriving at an opinion is, having heard all the evidence, such evidence, should it be presented to a criminal court, which is then the prerogative of the National Prosecuting Authority, it may lead, if it's found to be credible, to a conviction.
Yes.
But I'm not in any way contradicting the concession I made that I had erred in the manner I had stated it in my
in a manner that you indicated that the test to be applied should be applied. So what you are tentatively saying is that there is a justification for an opinion.
I can do no more than that, my lady.
Yes, if I may, are you saying that there is a justification for an opinion that the court might arrive at the end, that there is prima facie evidence that could be may be found credible or acceptable in a subsequent trial?
It is with the fact being kept in mind. It's not in any manner am I submitting. It has been proven such, my lady. Because the prima facie, as I've endeavored to submit initially, my lady, refers to the end result should your ladyship reach and rule an opinion adverse to certain officials. My submission is those are the officials involved. Keeping in mind there's no checks and balances, no programs to address the fears and the concerns that were raised by many parties, my lady. And I'm not going to repeat all of that, my lady.
Yeah, but I'm not sure that I now understand you, because I thought you were just retracting from the statement that whoever you said in your case that could be held criminally liable, you are retracting the word criminally liable, right?
Yes,
and
yes.
the fact that those people, according to you, whom you had indicated that
retracting
they
that they
could be
criminal
arraigned in a criminal court, but you are now changing to say
Yes, ma'am.
there could be justification.
What I'm just
Or
if
yes,
I'm submitting there are facts which would justify your ladyship in exercising and concluding
mhm.
and handing down a ruling. Well, if maybe it would
that there
or
may be
and
acceptable and credible evidence that could be used at a subsequent criminal trial. That's what you are saying.
No more than that, my lady.
Okay. Mr. Sibara, I hope that's how I understood him.
My lady, the confusion cancer is setting in far deeper, but however, the conclusion of the conclusion of my senior.
In fact, how I understand him, I don't know, but
Yeah,
perhaps it's just a question of semantics here.
definitely, my lady. I don't think we'll be very much worried about his final remarks on our side, my lady. As long as,
all right, but as long as you understand what he means.
Yes, paragraph 9.2 has been considered. It was
All
erroneously. Then we are happy, my lady.
Okay. Is that all? I hope you have.
Sorry, my lady. I've concluded my submissions to your
Yes,
ladyship.
before I release you, can I hear Ms. Sabuko? Ms. Sabuko? I saw there was a hand by Ms. Sabuko. You are muted. You are muted.
It's showing that I'm not. Am I unmuted, my lady?
Yes, you are. We can hear you now.
As the court pleases, I just want to clarify something with Advocate Pienaar, if it pleases you. I think there's a confusion on my part in respect of a submission or a statement he made. I appreciate that the paragraph 9.33 on page 55283 has been withdrawn. However,
Yes, withdrawn paragraph 9.2.
9.2, yes, as the court pleases, my lady.
Yes.
However, if I may just try to repeat what Advocate Pienaar he said, no evidence devised that a program was devised with checks and balances to alleviate fears and concerns by public and private practitioners. Before he made this statement, he referred to Dr. Libete and I think Dr. Manamela, he said. So I just need to understand the conceded or the withdrawal of paragraph 9.2 against a reference to Dr. Libete and another. Is Advocate Pienaar saying, in spite of the retraction of paragraph 9.2, those the statement he made still remains in respect of, amongst others, Dr. Libete, whom I represent?
Okay, he can answer for himself.
As the court pleases.
May it please the court, my lady, with all due respect. The statement I made was if I can call it a positive statement, that the officials listed in paragraph 9.3, whereby is included Dr. Libete, should be arraigned in a criminal court. There's prima facie evidence that they are liable. And that's been retracted in toto, my lady. I've explained that.
Yes.
My submission, all that remains, my lady, is to submit, depending, or rather, there is evidence I submit, my lady, with respect, that could assist your ladyship in arriving at a founded opinion.
Okay.
And I'm not venturing further than that, my lady, because I cannot usurp your ladyship's prerogative of arriving at an opinion, nor am I endeavouring to be prescriptive to your ladyship in the opinion to be arrived at, my lady.
Okay, thank you. There you are, Miss Soboko.
As the court pleases, my lady.
Yes, do you still have concerns?
I have been clarified. Thank you, my lady.
Okay. Thank you. I see it's about 28 minutes past 3. I think we can call it a day and resume tomorrow.
May it please the court, my lady.
Oh, let me check where's my list. Just to check who will be making submissions. I see Mr. Watpringle, SC, Mr. Odes, Miss Seboko, and if possible, Miss Ramaimel. Yes. I saw two. Thank you, Mr. Pina. I saw, what was it, 2 hands, and then one is Mr. Martin's hand. I don't know if I noticed the other hand. It looked like there were 2 hands. Was it his only hand?
I only saw one, my lady.
Oh, okay. That's fine. Mr. Martin?
My lady, I just wanted to let you know, Mr. Watt Pringle will not be making the argument tomorrow. It will be me. He tenders his apologies. He tried to have himself excused from another matter, but when we could see that the argument was really flowing quite quickly, we thought it would be safest if I just dealt with it. So it will be me in the morning.
Okay, that's fine.
As it pleases your ladyship.
Thank you. The proceedings are therefore adjourned to tomorrow. Tomorrow is the 31st of October 2023. Thank you so much.
As the court pleases.
As the court pleases, my
May
lady.
it please the
As the
court, my
court
lady.
pleases.
As your ladyship pleases.
As a court please, my lady.